Good evening to my lecturer and fellow friends. My name is Joshua. Before starting the presentation, I will introduce my group members. First, Muhammad Adri, second, Adrian, third, Ahmad Juhimi, and lastly, Muhammad Akai. Today, I will present the introduction of Taxation of year 2020, which is IBM Malaysia Sedia Berhad Bersyuk the Director General of Ilm Revenue. IBM Malaysia Sedia Berhad is the company that purchases, distributes, and markets better computer software and the hardware and provide the information technology service to the customer. This text is about the conflict of double taxation agreement between the Director General of Ilm Revenue and IBM Malaysia Sedia Berhad that handled by the Federal Court. Let us look at the background of this case. On 12 April 2016, IBM Malaysia Sedia Berhad applied a requirement based on the Section 138B of the Tax Act 1967 to the Director General of Ilm Revenue to look for the advance ruling or whether the payment paid by the IBM Malaysia Sedia Berhad to a non-registered IBM Ilm Product Distribution Limited is categorized as a royalty and is subject to the withholding tax. In order to achieve this purpose, IBM Malaysia Sedia Berhad has submitted the label document that consists of the draft copy of the agreement between the IBM Malaysia Sedia Berhad and IBM Ilm Product Distribution. After this, a ruling was issued by the DGRI on 7 June 2016. However, IBM Malaysia Sedia Berhad expressed that this fee is actually not a royalty and tried to file a judicial review looking for the order categorically to scrap the decision of the DGRI or issue the ruling. Then, the High Court allowed the requirement for judicial review made by the IBM Malaysia Sedia Berhad on 27 March 2016. The DGRI made an appeal to the Court of Appeal against the decision of High Court Judge. Finally, the Court of Appeal unanimously approved the appeal of the DGRI on 19 February 2019. Thank you. That is all for my part. I will pass the presentation to next member.
The four issues in these cases: firstly, whether the advance ruling is a decision which is binding upon the respondent. The advance ruling that issued by the appellant is a decision that is final and binding in nature. Law it is clearly reflected, which is been explanatory in Clause 26 of the Finance Bill 2006, Clause 26. Any person can request to the Director General on the Inland Revenue on the application of any provision of Act 53 to a particular type of arrangement. The advance ruling have been requested between these two persons, which is the person that requests and that person have to approve, which is Director General, binding each other. Second issue, whether the application for judicial review is premature. The advance ruling is a decision which is altered and deprive the respondent of its right by subjecting the distribution fee to withholding tax, as the respondent will suffer financial detriment and will have to pay tax. The judicial review application is not premature. Advance ruling is decision which is binding upon the respondent. The land judge is correct in holding that the application for judicial review is not premature. The third issue is whether the domestic appeal remedies under the ITA are available to the respondent. In these cases, we found that the right to appeal a remedy under Section 99 for the respondent are not available. The appellant will issue assessment only after the respondent had filed and submit its tax return. But in these cases, the fact is that the respondent has not yet to submit the tax return for year of assessment 2016. Lastly, whether the distribution fee payable under the agreement is a royalty. The distribution fee payable by the non-resident PDL are not applied for the ITA. This is because, as for royalty, the definition under double taxation agreement applies, and not the definition under the ITA. The distribution fee payable to PDL under the agreement for the purchase, distribution and sale of PDL product such as software programs is not a royalty.
Now, I'm gonna talk about the rules related with the case. Section 138B of the Income Tax Act 1967 tells that advance ruling on the application to the IBM Malaysia and the arrangement will be made by Director General in the prescribed form with the necessary particular required by the Director General. Paragraph 21 of the Income Tax Act, Advance Ruling 2008 PUA 41/2008 tells the scope of the advance ruling is on the how the provision of the Act will apply to the IBM Malaysia and the arrangement. Paragraph 2.3 of the rules tells that DGIR will issue the advance ruling for serious contemplated arrangement. Order 53 Rule 24 of the Rules of Code 2012 give entitlement to the adversely affected person by public authority decision for submitting judicial review application. Paragraph 7.1 and 7.2 of the rules, DG determine what form for the applicants of advance ruling to be made. For example, submit the applicant's identity, documents and fact with full details related with the arrangement and anything required by the Director General. Paragraph 10.1 and 2 of the rules tells the form and nature of an advance ruling. In this example, DG must clearly state under Section 138 the applicant's identity, arrangement and acts provision, how the provision applies to the person and the arrangement, and period of assessments. Paragraph 14 of the rules, application must not to affect objection or powers. Applicant cannot be free from the Act's obligation or requirement compliance. DGIR power of making or amending assessment under Act's provision also cannot be affected. Paragraph 15 of the rules, disclosure of the advance ruling in tax return whether or not the applicants relying on it. Paragraph 16 of the rule, advance ruling arrangements are final and appeal cannot be lodged against it. Section 2.1 of the Income Tax Act, definition is in line with double taxation agreement. This is to tell about the royalty. Consideration received from any sum paid for the right to use of copyrights, design, and software.
For application part of this case, there are two questions to be determined. The first question is whether an advance ruling issued under Section 138B of the Income Tax Act 1967 or ITA is a decision which could adversely affect the appellant within the meaning of Order 53, Rule 24 of the Rule of Code 2012 or ROC. And the second question is whether the definition of royalty under double taxation agreement shall prevail over the definition of royalty under Section 2.1 of the ITA. So for the first question, it's basically asking whether the judicial review on advance ruling is a proper remedy for IBM Malaysia which adversely affected by the advance ruling. Order 53 Rule 24 of the ROC stated that any person who is adversely affected by the decision of public authority shall be entitled to make an application for judicial review. The advance ruling is only a view or interpretation by DGIR based on the factual background of the application made by taxpayer. DGIR shall make an advance ruling on how provision of Act apply. This means that advance ruling is made based on provision of Act and not merely a decision of DGIR. By referring to the case of Government of Malaysia and ANA against Jagdish Singh, the court has decided the remedy by way of judicial review shall not be available when alternative remedy exists. In this case, referring to Section 99(1) of ITA, IBM may appeal to Special Commissioner when aggrieved by assessment made. Appeal to the Special Commissioner shall be the primary option of remedy for IBM Malaysia instead of judicial review in this case. Income Tax Advance Ruling Rule 2008 Rule 16 stated that the advance ruling issued to any person for the purpose of any arrangement shall be final and no appeal shall be lodged against the ruling. IBM have a choice to not to bound with advance ruling by avoiding the whole proposed transaction at all. The move of IBM Malaysia to file judicial review was premature and abuse of court process. The next question is on whether the definition of royalty under DTA shall prevail over this definition of royalty under Section 2.1 of ITA. The definition of royalty under DTA is in line with definition given under ITA. Thus, there is no issues of conflicts between DTA and ITA. There are no facts established that the payment for distribution fees received by the non-resident is a business profit.
For the conclusion of this case, this is the maiden decision on an advance ruling issued under Section 138B of the Income Tax Act 1967 by the Director General of Inland Revenue. The key issue in this appeal by DGIR is whether an advance ruling constitutes a decision amenable to judicial view. Briefly, the Court of Appeal unanimously allowed the DGIR's appeal. The court held that the advance ruling is not a decision and that it merely represented the DGIR's view. Further, IBM is not adversely affected by the advance ruling because the DGIR has yet to issue a tax assessment. IBM was granted leave to appeal the apex court. However, the appeal was unsuccessful. The federal court grounds of judgment are not yet to be available. Under the self-assessment system, IBM will have to comply with the advance ruling when submitting its tax return. This at the pain of penalty and a fine for filing an incorrect tax return. IBM is adversely affected the moment its tax return is submitted, as the tax return is deemed a tax assessment upon submission. In our point of view, appellate courts did not fully appreciate the interaction between the advance ruling and the self-assessment system. It will appear that IBM would have been adversely affected by the advance ruling due to the risk of penalty and fine.